just wanted to know, is it essential to keep the video camera on throughout the session?
No. Only recommended during the first 10 minutes and last 10 minutes of the session.
Okay.
Yeah.
Thank you.
After the data privacy has come, sir, nothing can happen without your consent. So don't worry.
No. I am asking because of the bandwidth issue,
No, absolutely.
And
Just
the
kidding,
video
sir.
is on, and then from the other side, the slides, etc., are presented. So I don't want an interruption in that video,
No, absolutely.
That is the reason. And I am actually logged in through the mobile device.
I understand.
And that is the reason I'm asking for, because I tried first logging in as a login using my email, but then I was unsuccessful. So then I logged in as a guest, and it then allowed me to log in as a guest.
No problem.
No issues, sir. Yeah. With your video on, you also have your evidence for your CPs.
Sir, ISACA needs proof that you have joined.
Okay. Thank you.
Right. Good, sir. Shall we start? I think we have 90 participants and on time. Yeah. So, good evening, everyone. On behalf of ISACA Mumbai chapter, I welcome you all to this, very latest topic, which is there on Digital Personal Data Protection Act. As you all know that, the president has given assent to it on 11th of August, just less than a month back. And we have with us very learned faculty, a speaker, and our very own ISACA, board member from Bangalore chapter. He's a program chair of Bangalore, and Narasimhan Elangovan. So he's there. I'll just briefly introduce him. So he has multiple qualifications, you name it, from BCom, CA, CS, DISA, Diploma IFRS from ACCA UK, LLB, and CISA and CDPSE from ISACA. He's a senior advisor, Digital Security Services, Crow Advisory Services India, LLP. He's a futurist cybersecurity auditor and a keynote speaker. His areas of practice include cybersecurity audits, SOC 2 and ITGC attestations, auditing emerging technologies such as AI, big data, IoT, etc. He's a faculty for DISA, CISA, and courses on blockchain technology. He has authored more than 7 books for ICI, KSCCAA on technology. He's a regular speaker on technology at various national and international conferences of ICI, ISACA, CII, FICI, etc. He has often addressed ISACA international conferences of Asia CAX, Europe CAX, Africa CAX, Northern America as well, and often amongst the top rated and the youngest speaker. He has been identified as one of the top 10 influential consulting leaders 2020, an annual recognition for torchbearers in the consulting sphere by CEO Insights magazine. So with this brief introduction, I welcome you, Narasimhan, for being with us, and over to you to share the knowledge. Thanks.
Thank you so much. Quickly sharing my screen. Let me know once you are able to see this slide, which is.
Yes, we can see.
Yes, it is visible.
Yes,
thank you.
I'm able to see. Thank you.
Thank you. So first and foremost, thank you everybody for joining in. It's wonderful to meet once again. I think a few years back during pandemic, I of course did interact with a few of you out here, but it's good to meet all of you. Thank you for taking your time out on a Saturday evening. I know it's a family time, but considering that this is also an important legislation, I think worth spending some time and some thoughts over here. So before I head into this, let me also give you some thought process and perspective. First and foremost is the concept of privacy has seen a larger evolution which is actually going on in the last few years. And not just that is happening from a global front, India also it is taking place. So what happened earlier, if you see the last 2 decades, the focus was heavy on information technology coupled with security. Now, probably in the next few years, or probably it's the next year or a decade or so, I would say the focus will shift security and privacy. Of course, what is security, privacy will address all of those things, right? We'll get in some perspectives. I think just have that into your mindset, and we look into this gradual progression. Let me also remind you that while we speak and while you may ask questions, I only know the law as well as you can read the law, right? Because the law is just, receive the president's autograph, if I could probably call it on a lighter note, right? So the president's assent, we call it. And we are awaiting for the date of notification, but as we'll bring it that as and when it goes through, right? So I think introduction about to myself was given. In simple or in one line, I'm basically a technology enthusiast. I like seeing how best technology can be used to manage risk as well as, to manage the overall landscape. And that's how I basically picked up technology, mostly a self-taught and a self-learned gentleman. And that's how I've been able to pick up and share a lot of insights and thoughts. And the only reason I do these sort of webinars or sessions is at least for that reason I will read on a lighter note. Okay, I'll broadly take you through about 4 to 5 broad areas, because I know I want to keep it a little light. I'll bring in a lot of practical illustrations as much as possible, give some bit of a background, get into certain definitions and key provisions of the act, right? And then we look into some insights and way forward what organizations ought to do, and various things on that, right? So first and foremost is, how did this act come into picture, right? And if you talk about the history, I'm not going to speak too much about it. Let's talk about how in general protection, data privacy started evolving. So way back in 1984, the Data Protection Act was passed in United Kingdom. Look at this. It was a Data Protection Act. It didn't focus on a privacy element, right? And then what happened in 95 was a major milestone where the European Union spoke about Data Protection Directive, right? And many of them think that GDPR was the first biggest privacy related initiative. No, my dear friends. While 2012, you had this GDPR come into picture, 95 itself, we had a major directive which came in. I'll probably put it as the old GDPR for the simplicity's sake of our understanding. And this came up in the year 95, which was applicable typically in the European Union. And please understand, European Union until the Brexit included even the United Kingdom, right? So that parts of it. Then UK came up with a act a little later. Then came up a very, very interesting regulation called International Safe Harbor Privacy Principles. It was predominantly an agreement between Europe and the US, how they could share personal data. That's all about it. It was an agreement between Europe and US as to how they could share data, including PII, etc., and ensure certain safety precautions are taken care. And those were considered as the safe harbor rules. Of course, a couple of years back, by the Schrems II judgment, it was negated. We are not going to spend too much time onto this because our focus is just to give you the context. 2012 saw a major game plan shift, and that's when GDPR came into picture. And the only reason GDPR became very famous, my dear friends, is because of this clause on penalty. The penalty in GDPR, I think most of you would have heard, is that 2% to 4% of global turnover. And that's when it caught all the attention, right? And 2015, again, these safe harbor rules were sort of discussed, overturned. Then EU-US Privacy Shield sort of replaced it, and sort of, sorry, if I could request everybody to be on mute just to avoid that confusion. Thank you. Right. In 2016, we sort of saw this privacy shield, safe harbor rules. 2016, the GDPR was approved by the parliament, and 2018 onwards, it became effective. And then we saw various countries coming up with their own set of privacy laws. And in 23, India came up with the Privacy Act itself, right? But if you look into Indian context, right, if I have to give it very, very specific, this entire evolution started only in 2017, where there was this beautiful judgment by, it's called as the Puttaswamy judgment or Puttaswamy case, where for the first time ever in the history of India, right to privacy was recognized as a fundamental right. I'm not going to go to the nuances because our focus is more on the act, but just giving the context, because without knowing the history, it doesn't make sense in accelerating. The first time ever, fundamental right, it was recognized. And when you say the fundamental right, that means every citizen or every individual who's within the territories or, within the country is expected to have that sort of a right? And that was the big change. And then consequent to it, the very year later, Sri Krishna committee came up, where they came up with beautiful or interesting perspectives of the Data Protection Act or the Data Protection Bill. And they came up with various recommendations, studying the intent context, coming with a few suggestions, various things. And the moment they came in, India started recognizing, hey, something on privacy is going to happen in India. 2018 to 21, there were 3 data protection bills which came up. I repeat, 2018 to 21, 3. There was a personal data protection bill of 2018, 19 and 21. Each of them had variations, right? And as though this was not sufficient, every bill keeps on coming. What happened? In India, people started thinking, okay, this is never going to get passed. Like, if you recollect, many years back, we had this GST law, which was brought in India. So every year, every time people kept on saying, we'll bring in the GST regulation. But over a point of time, it never happened. But finally, the government took a stand. The same way, 2021, it was all personal data bill. 22, they did a major shift. They removed the word, or rather they prefixed the word digital personal data protection bill. Look at that smart thing which they did, right? And in 23, they finally passed this DP Act. And the moment they passed this, right, even people thought, okay, Lok Sabha, it will get cleared. Rajya Sabha, it will take its own time. Rajya Sabha, it will clear, president has to sign, it will take its own time. And actually it happened over a point of, probably 2 weeks. I think less than 2 weeks, right? This entire process. Of course, there's a lot of deliberation which has happened. I'm not denying on that, but at least this sort of process went. Now that given this particular setup is done, right, we have understood the Digital Protection Act is actually 23 they've enforced. What actually is the purpose of this act? Let's go into the specifics of that. And I'm going to talk about certain things which are very crystal clear what the law says. Beyond that act, I'm not going to touch upon anything else. Of course, I'll give you certain comparisons and nuances so that you understand. A quick example is, I think you are able to see my PDF document. It says the Gazette of India. I hope you're able to see that. Yeah. So in that, it will say published by authority, etc. Ministry of Law and Justice. And this is basically the Digital Protection Act. Just Google it, you will be able to get it. What the date you see there? 11th of August 2023. Probably about 3 weeks old. Right? 3 weeks old. And for the first time in India, this act has got very, very interesting things. First, it is just a 21-page act, which means in an Indian context, it is one of the smallest acts, if you ask me. One of the smallest acts, right? You can probably look into this, right? Including the annexure and penalty provisions, etc. It just runs into 21 pages. So the government is obviously looking at certain things differently. First. Second, they said the references in this act for the very first time in the history of India, a female connotation is given, meaning everywhere they say, generally in an act, they talk about he, whosoever shall, or his. That is the wordings they use in any of the acts in India. For the first time, they gave a connotation of she, right? And it doesn't mean that, obviously, it's a general clauses act, because if you read the general clauses act, it says he includes she, because it was a male, perspective was predominantly looking from a male-based system. But now the government also recognized, hey, there's nothing wrong in calling out as a she. So which is again a welcome initiative, right? So those are a couple of quick things which is a change. And the third, this is purely a principle-based law. There are a lot of places where it says as may be prescribed. For example, I'll just Google search here, or rather, I'll just do a control F here, right? I'm just typing the word prescribed, right? You can see it for yourself. if I type the word prescribed, right, you will find 31 times ignoring few things, at least 25 to 30 times the law says as may be prescribed, which means it is more of a principle based law. The finer nuances are going to come into detail a little later, right? So that's basically the thought process which I wanted to give it, right? And it provides for processing of a digital personal data. What are each of these terminologies? We'll look into it. The whole purpose is to protect the right of the individual. Remember, go back to the Puttaswamy judgment. What did the Supreme Court recognize? Privacy is a fundamental right. So right of an individual. There are some other acts in India which also focus on rights of individual, like the Consumer Protection Act, right? Quite similar to that. And need to process the data only for lawful purposes. Every word is critical because the word processing itself is very unique here. We'll spend some time on it. Then comes a very interesting question. Is this act applicable to me as on date? The answer is no, because the president has signed it on the 11th of August 2023. However, the date on which from which it is going to be applicable is not yet notified. And very, very important, they use the special wordings which I want to draw all of your attention, right? And I want you to look from the angle little bit like of a lawyer who can look into the law, as well as from a practitioner as a consultant, whatever you're looking into your domain, so that you can merge both the perspectives. The interesting thing is the last line which you notice. Different dates may be appointed for different provisions of that. Very interesting. Different dates may be appointed for different provisions of that. That means they can, by virtue of circular, notify these are the sections which are applicable, these are the subsections which are applicable, these are not applicable. Sir, that means, is the law going to be implemented in piecemeal? You heard it right. Yes. The law is going to be implemented in piecemeal based on the way they are going to notify. And bear in mind, this is the bare principle. Basis this, a lot of regulations are also going to come up. A lot of authorities also have to come up. So there's going to be an interesting turn of events over there. We will look into it as and when it comes. So I hope the fundamentals and basics all of us are clear. Taking this a little ahead. Before even going into the act, right? One of the biggest misconception with all of us is data security and privacy is the same. Or data security is a subset of privacy, or privacy is a subset of security. No, I would say probably there are two different sides of a coin. Sometimes some of the coins may have only one side. This is a very unique scenario, right? And also there's an element of data protection. So I'll give you a perspective of all the three. Now I am giving you my business card, or I am sending you my bank statement, or I am sending you my health record. Now you are keeping this in the most secure environment. It is safeguarded. Nobody can access it. Nobody can alter. The CIA is insured, and I'm sure all of you know what CIA is because most of us deal with this day in and day out. This is security. Then what is privacy? Now the same thing, my record or my details, your vendor is having access to, or you are only one person is having access to it, but you are using in a manner which is detrimental to me, or you're using in a manner to advertise something to me which I never said. Boss, I gave you my bank statement because I wanted you to file the income tax return, or I wanted you to file the apply for a loan statement, but you are actually using for XYZ purpose. This is where your element of privacy comes into picture, right? That means privacy is one of probably the pillars, right? Focus on personal data, how it is collected, how it is used, and how it is stored. Whereas security is basically safeguarding from unauthorized use, breach, and etc. Right? When it comes to privacy, there are a lot of rights involved. Why are you collecting? What are you going to do with collecting that? Right? All of those comes into. And the last pillar is the data protection. right? This is an element or a combination of both security and privacy, right? I hope you got that basics clear, and I wanted to make it very categorically understand it, right? At this point, I'll quickly give a 10 to 15 second sort of a summary that the act is already come into picture. The notification or the date on which it is effective is not very clear. They may notify the acts in piecemeals or in entirety. We need to wait for that. And this is called as the Digital Personal Data Protection Act, DP Act, right? No longer DP bill. I hope the fundamental first set of basics are clear. Quickly moving to certain key definitions worthy to spend some time over here. First, the meaning of the word data. I think this is mostly understood by all of us. Representation of information, facts, concepts, opinion, instruction in a manner suitable for communication, interpretation, or processing. Very interesting is this last two words. Human beings or automated. What does it say? Human beings or automated. That means even if a machine is processing the data, which means they're indirectly referring to AI, advanced data analytics, etc., it will still be called as data. It will still be called as data. So please keep that in mind, right? First, data element. Second, when it comes to the element of personal data, means any data about an individual who is identifiable by or in relation to such data. Beautiful wording. That means any data about Mr. X or Miss Y who is identifiable by that data or in relation to such data. Now that brings in a very, very interesting conversation, right? Of course, digital personal data means any personal data which is in digital form. We'll come into those three things. So I think the concept of data is fairly clear. Just to give an example, and a photograph, will it be a data? The answer is yes. A medical prescription, will it be data? Yes. You're forming an opinion about certain things. An interview result, that's going to be data. Your bank statement is going to be a data. Credit score is going to be a data, right? You are going to, anything which you feel relating to, a larger perspective, which is a fact concept, is going to become data. But now comes the element of a personal data. Do corporates have personal data? We'll take that question, right? Now, what is personal data? Now, please bear in mind the distinguishment the act makes between person and personal. The act is applicable from a personal data standpoint because digital personal data. So personal data is applicable only when we are talking about data of an individual. And who is this individual? In general parlance, individual is interpreted as a living human being. I use the word in general parlance. Why? Can a dead person also be a personal data? 100% yes. Right? Because you're talking about personal, anything which can identify the person. Now you might be thinking, sir, if that person is dead, why are we really bothered about, his information? You never know. If we are talking about a medical history about a person, and let's say he is having some genetic disorder, so his children will now have a challenge there, right? Okay, sorry, I'm getting a message that the voice is not very clear.
Good. It's good.
It's good.
It's very clear. No issues. Very clear.
Thank you.
Okay.
Yeah, thank you.
Narasimhan, if you can permit me, I'm higher here. Wanted to know, when in the second, personal data means any data about an individual, does it mean the organization will have to first establish the ownership?
I'll come to it, sir. I'll come to it. Just give me some bit of thought process. I will get the flow, because there are a lot of questions which is slightly each person interprets it differently based on their organizational context and their experience of looking into it. So just give me a few minutes. I will take you with the flow, and then we'll pause at frequent intervals. I really appreciate your participation. Okay, when it comes to personal data, as I was saying, it means data about an individual. So individual in this context is referred to as a human being, a person, right? Now that is something which we will have to look into it, right? Because the personal data means the data, this is defined in the definition clause about an individual, right? Now comes an interesting question. Sir, can I interpret individual as a dead person? I think I already spoke about it. How about my, pets, my animals, friends, or whatever is there? I think the law, unless it is a specific law for these, I don't think we make a mention of any of these people as an ambit of law. For example, Animal Cruelty Act will speak about different things. So therefore, I think it's very clear from an individual. Now coming to a company, right? If you look into certain laws interpret company, a partnership firm, an LLP also as person, right? And this is where the beauty of this Digital Data Personal Act is, where they say person includes individual, HUF, partnership firm, LLP, private limited company, all of those. However, personal data means data about an individual only. Are you able to get the difference? Are you able to get that sort of alignment? Which means if I am storing a database of various companies, Accenture, IBM, ABC, and let us say I have the company's contact number, not identifiable to a particular person. I have support at the rate that company. It will not constitute personal data, because look at the definition of personal data. Means any data about an individual, and that individual should be identifiable, right? And very, very important, personal data is always contextual. What is the meaning of a contextual? I have, let us say, the name of a person. I have the name of a person. Let us say the name of the person is, just say, Narasimhan. Will this constitute personal data? Generally, yes, because the name will constitute personal data. But just because my name got breached, or just because my name got accidentally released, will it imply that I have to pay penalty, breaches, etc.? Generally, no, because Narasimhan could be anybody under this planet. That is why I keep on saying personal data is contextual. And also now let us try to relate how we store data. Typically in any organization, your data is stored what? In tables. You have an RDBMS setup. 99% you have RDBMS setup. You have those variations of, various types of fancy database. Now, whatever type of database we are speaking of, don't you think we will have rows, columns where data is getting stored? Now, if one column in that data gets lost from a context of a breach perspective, right, it may have to interpret it along with what is the extent of data lost. So always bear that in mind. So never think, oh, every detail which I have in my organization is personal data. No, why I'm telling this is because unless you do that, draw the box, what is that personal data and how much I need to protect, I think this act, how much ever you read, you will only get scared. Let us understand this act is a reality. We always thought, India mein privacy nahi aayega. India mein privacy kya hai? Many of them says, what is privacy, right? So please be a little cautious there. And digital personal means personal data in digital form. Matlab, sir, I've got Aadhaar printout. I think everybody agree that Aadhaar is a personal data, right? Because you can identify a person with that, right? I think that's clear. I have an Aadhaar driving license printout, paper form. Is it digital personal data? No. So the act is not applicable for that. However, I have the soft copy of this Aadhaar, then it is applicable. Are you with me? So you go to a hotel, when you're checking in, you are giving a physical copy of the Aadhaar card or your driving license. Digital personal data does not get attracted. I'm not saying the act is not applicable, please bear in mind. I'm saying to that extent, the digital personal data definition does not get attracted. Other clauses we may have to interpret. However, the same hotel says, sir, we are completely digital. We will only take a photograph of your ID proof, driving proof. Digital personal data gets attracted. I hope you're clear with this. Some of the few questions which has sort of come up. How about director's information stored, right? The moment you can trace with a person, it becomes personal data, right? The moment, it depends on the data, and I told you it's all on the contextual scenario. I'm taking this conversation ahead. I will definitely pause for breaks and questions. So what are a few examples of personal data? And interestingly, okay, by the way, globally, if you look into it, there is also a special category called as sensitive personal data. In fact, in India, currently, as on today, we still have sensitive personal data. How do I get it? Go and refer the Information Technology Act and the relevant rules. Information Technology Rules 2011, sensitive personal data, SPDI we call it. There they have clearly mentioned bank, Aadhaar, passwords, username, biometric, health, sexual orientation, all of this are treated as sensitive personal data. Even in the bill, the previous versions, there was a mention of sensitive personal data. However, the Act has now removed that. So there is only personal data, digital personal data. I hope all of you are clear with this, right? And the Act applies only if your data of a personal, of an identified person or whoever it is, the personal data is in digitized form. I hope that equation is clear. Applicable, because if the Act itself is not applicable, then why are we going into the nuances? Are we clear with this, right? Okay. Now these are a few illustrative, again not specified in the Act. This is given from a general example, right? This is given from a general example based on historical practice. All these are treated as personal data. The color code is just to attract your eyes, nothing to do with, something is highly sensitive or less sensitive. Everything is treated on par with each other at this particular point in time. Tomorrow, the government may come up with certain specific regulations. That's a different scenario. That time Murtaza will call me for another session. That time we will discuss a little in detail, right? But on a lighter note, but I hope all of you are clear with this, right? Now you might find certain unique information over here, right? Date of birth, I think most of us know. Income tax details or tax identification number, passport details, right? Social security number. Please note, India does not have a social security number. Don't say India social security number is Aadhaar. No, India does not have a concept of a social security number. Aadhaar is an identification number. It clearly says, even the Aadhaar Act, if you read, says it's a mechanism to identify that this is Murtaza, this is Narasimhan, this is Mr. Iyer, or this is Mr. Mahesh. And how do I identify? By two mechanisms. One is an OTP, other is a biometric. That's a different story. We'll not bring up that, right? And you will find cookies, right? Cookies. The computer cached cookies are also a personal information. Very interesting, right? And because today we get so much of advertisements based on these cookie only, right? Bear in mind, if Google, you would have searched some product on Google, or you have searched something on Amazon, and the product follows you for next 3 days because of the IP address and cookie. Right? So therefore, that information is collected. Now, does Google or Amazon get to know that Mr. ABC from Mumbai is searching for this particular product? No. They only know that they have a potential customer in the location of Mumbai. If they are able to get to know your details, including your photograph and other things, be assured that you have been breached. Right? So that is where it comes into context. Right? Now, some of the most popular questions. Sir, can handwriting become a personal data? Again, remember, all of this are scenarios of a context. Sir, I have a handwriting paper and that has been leaked. Is this a personal data? You cannot read in an isolated environment. That is the first thing which I'm trying to tell you. Because your handwriting today will be different. Few years later will be different. Forget that, sir. If you are a student, and I know all of you as students, all of us as students, we had the 3 hours examination hall, right? We were spent on this thing. Interesting is the first 1 hour, just on slightly on a different note, right? Just on a lighter note. The first 1 hour, what we write in examination, you also understand. The person who is, evaluating your paper, he'll also understand. The second 1 hour, what you write, only you will understand. He will not understand. The fellow is correcting your paper. The last 1 hour, what you are writing, neither you will understand, neither that person will understand. Right? I'm just giving on a jovial context, right? So will handwriting become personal data? The 100% yes, but again contextual. You have to relate it with certain other attributes. So just because my handwriting got leaked, you never know. There are certain people who are known for their beautiful handwriting, and if their data gets leaked, it could be one of a kind. Yes or no? A person's artwork or a painting could probably be read as a personal data. So you'll have to read it contextually in your organization, how you collect and how you process it. Are you clear? Some other question came, education history, is it personal data? Let's say you have an educational history about a person called BCom, and you have an educational qualification of a person who has done 25 degrees, right? Let's say, you know, somebody who's done 25 degrees, I'm sure Murtaza, I don't know how many he's done. I'm just picking up Murtaza because, you know, he's a good friend of mine, just on a jovial context to get the, the conversation going. But let's say Murtaza has has done 15 qualifications or 20 qualifications as an example. Now, the number of people in India who's done the 20 qualifications are very less. Let's say it is about 100 people or 1,000 people. Can I identify this with that person? The answer is yes. So therefore, the context of the data keeps on changing. Bear that in mind, right? So now that we have got the definition of personal data, the next definition, which you should be very, very clear, is this 3 pillars: data principle, fiduciary, process. Data principle is popularly referred as data subject in GDPR and rest of the world. In fact, they call it as subject access rights and other things, in case you have done some work in privacy. But otherwise, just retain this for the time being, data principle. That means he or she whose data you are processing, right? Say, for example, you go to a hotel to check in, you are the data principal. You are buying an insurance policy, you are the data principal, right? And interestingly, for the first time, they have linked an age factor also. In case of a child, the data principle is not just the child. It also includes the parents or a lawful guardian of such child. It used the word parents or lawful guardian of the child. So in generally, the definition of a parent is obviously understood. The guardian definition is based on, again, the act and the general clauses and the interpretation. In case you have, you don't have a parent, then 21 years up to that age, you know, somebody has to become a major, only then you become an attained majority. However, here the law is very simple. 18 years is the cutoff. Now, this is very, very different and contrasting to the European regulations, because in European regulations, the child definition is not given under the GDPR. It is given based on every state. Certain states, child is only up to the age of 13 years. Certain states, child is up to the age of 14 years, and some states 16 years. In India, they have said no, 18, full stop, dot. Tomorrow there might be relaxation, that's okay. That means those companies who are in educational industry, those who are into online coaching, anything of these fancy stuff, you are collecting children's information, please be very, very cautious that in addition to a consent of a child, you need to document consent of a parent. Now, how will you establish that this child's parent is this? That's a pure interpretation game, right? We are going to come into that a little later. I'll talk about some guidance also. I hope all of us are clear. Data principle is the person whose data you are processing. Similar reference in a GDPR is called as a data subject. Rest of the world also we use that. Second, a beautiful articulation by the regulator is the word fiduciary and not controller. The word fiduciary means a person whom you trust, fiduciary capacity. There is an element of a trust, and that is why that word also comes. So fiduciary is any person, and again here, remember, sir, here you are saying any person. That means fiduciary, is it only a human being? No. Individual? No. Here you go back to the definition of person. Who was the definition of person? Person could be individual, HUF, partnership firm, company, LLP, artificial juridical person, all of those. And it is quite similar to, you know, the Income Tax Act definition of a person, but we'll not go into too much of those details. So which means you are going to Tirumala Tirupati Devasthanam, Lord Balaji ka darshan you are taking. And if you have to take Lord Balaji's darshan, you need to have an Aadhaar card. I hope you're aware of that, right? So even God wants to authenticate you before you come inside. just on a lighter note, right? Because you need to pre-book an appointment and things like that, right? So which means if Tirumala Tirupati Devasthanam is asking you to upload their Aadhaar card, is Data Privacy Act applicable to Lord Balaji? The answer is yes. So therefore, even if Lord Balaji wants to know your name, right, DPDP is applicable. I'm just telling on a jovial note, but I hope you got the context, right? I'm just bringing some element of humor. I hope you don't mind it in the context of the overall interest. So data fiduciary, any person who alone, very, very interesting, alone or in conjunction with other persons, there could be one person or a group of person. The keyword is determines the purpose and means of processing it. That means he is a guy who decides how the data should be processed. That's all. He alone can decide. He can decide with a team of people. He can decide with a group of people. That choice is left. But he is a data fiduciary. Similar wordings as data controller, GDPR. And then comes processor. Processor is a person who processes personal data on behalf of somebody. And who is this somebody? Data fiduciary. That means data fiduciary gives the permission to the processor. In other words, processor does the job as directed by the fiduciary. A typical use case, you take an insurance or accidentally Mr. X or Y is admitted in the hospital. So Mr. X or Y, who is a patient, is a data principal. The insurance company with whom you have submitted the data for obtaining the insurance is a fiduciary. At the time of obtaining the insurance policy, you may have to undergo a laboratory checkup. So the lab is a processor. You are processing your, what is that called? Claim. The third party may be a processor, or a hospital sometimes may be a processor. Bear in mind, hospital can also be fiduciary. Because sometimes when you are getting admitted to the hospital, they might ask you for your PAN or Aadhaar. Maybe, right? In that case, we'll come to it, right? Okay, one question, will bank be treated as fiduciary or processor? Please bear in mind, there is no definition that I will always wear this hat and you will wear this hat. I'll give you a scenario. A bank can be a fiduciary also, processor also. Example number one, you are opening a bank account. You are submitting your KYC document. Bank is a fiduciary. I think that's a clear case. Now, you are eligible for a subsidy scheme for the government. You have enrolled everything with the subsidy scheme of the government. Let's say even that simple, what is that? The direct benefit transfer which you are getting, right? So the government becomes in this case the fiduciary. They are merely instructing the bank to make a payment. In this context, the bank becomes a processor. I hope you're clear. So never ever think I will fall in one of these hats. I could fall in all of them also. I could fall in all of them also, right? Then you can say, sir, I have a driver, you know, for the sake of my safety and security purpose, I've taken the driver's Aadhaar card and I've kept one soft copy with me. Am I a data principal in this context? We will address that in a few minutes from now. I'm just giving you different scenarios, right? I hope you're able to get that sort of a thing, right? So principal, fiduciary, and then comes your processor. I'll give another classical example which most of us follow. You may be processing some personal data, let's say a salary processing. Now you are a company, you have obtained your employees' details for the purpose of processing salary. So when you obtain your employees PAN, KYC, Aadhaar, whatever, you are employee is a principal, you are a fiduciary. The payroll software which you are using, hypothetically presume it's a cloud-based software where your data is going into that fellow's environment, he becomes a processor. Amazon, Microsoft, all of these organizations will 99% be a processor to the extent where we are hosting the services. When will Amazon or Microsoft becomes a fiduciary? When you are enrolling with Microsoft for your account, your details, etc. So the context is different. I hope you're able to get it. I repeat my example. You are a cloud-based company or a SaaS product, right? You are using, or let's say for your own IT, you're using Amazon services where your customer data is hosted in AWS. Amazon in this case will be a processor, you are a fiduciary because you have obtained the data from the context, right? So that means, are you trying to say Amazon will never be a fiduciary? They will become a fiduciary to the extent they are deciding the purpose and means of processing personal data, which means you are registered with Amazon as a key customer for whom they have to notify an update of a feature. In that case, to the extent of your email ID and your information, they become a fiduciary. That means I'm telling you, they wear multiple hats. So fiduciary and this is decided based on the context. I hope all of us are clear. Right? Okay. Before I head into this, sorry, I think I will cover the definitions and then give a pause there, right? Oh, this is a beautiful word. You see this entire discussion over here, right? I'll probably just highlight it. Any person who along with conjunction with other person determines the purpose and the means of processing. And also here, if you look at the word processes, that means we are using the word processes multiple times. What is the meaning of process? Interesting, right? What is the meaning of process? Look at the word processes, and this is where you will realize any fellow under the earth can become a processor, right? Look at this. A wholly or partly automated operation or a set of operations performed on digital personal data. That means, again, they're saying, boss, you are put only on digital personal data, and includes collection, recording, organizing, structuring, storage, adaptation, retrieval, use, alignment, or combination, indexing, sharing, disclosure, dissemination, or making available information, restriction, erasure by destruction. Look at the wording of processing. It is huge. It is huge. That means accidentally you touch the data, you're processing. Why did you touch the data? You may be touching it for collecting purpose, for recording purpose, for organizing purpose. It could be anything under this planet. You may be eligible. Are you clear with this? Which means you might say, sir, I am an auditor and the auditor wants to only view the personal data. Auditor is a processor. Why? Look at the word. Sharing, disclosure. Are you understanding this? Disclosure by transmission. I'm transmitting as a virtue of it you are getting to know. Dissemination or otherwise making available. Somehow I made it available to you. Sir, I've got view only access. It doesn't matter, sir. You're a processor. So that means, sir, I am an ISO 27001 auditor. As a part of my audit, my client gives me access to digital data or whatever information. You may get covered within this. But please bear in mind, are you having access to digital personal data? That is the first question you need to ask. If he is giving SOPs policies, I think that is fine. I hope you are able to get the context, right? The moment we have understood all of this, the next word we have to understand is breach. Yes or no? Because we understood so many players, the next word you have to understand is breach. Breach means any unauthorized processing of personal data. Beautiful wordings. Any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, loss that compromises the CIA of personal data, which means you took one data of Mr. X and send it to Mr. Y. Personal data of Mr. X and send it to Mr. Y. Personal data breach. I hope it's clear. You sent all the emails, instead of sending CC, you send it in BCC. Sorry, instead of BCC, you send it in CC. And presuming, that email ID gets disclosed. It's a breach. I hope you're clear. That's one of the most common breaches, right? So processing and personal data breach, I think, is something very critical. We need to be very, very clear. And I think I've spoken on child. I'm not spending too much time on that because we are almost about good 45 minutes from the start of the session, and I've just come into, the key definitions, right? At this point in time, I'm just quickly checking if there's any other definition. Yes, we have 2-3 definitions. I'll quickly spend some time. Purpose, because note this, we spoke of data fiduciary who defines the purpose and processing. So we saw processing, we have to see purpose. Specified purpose mentioned in the notice given by fiduciary to the principal. This is what the beauty is, which means if you are collecting personal data, you need to notify the principal, who you means fiduciary has to notify the principal why you are collecting, how you are collecting, the notice. Your notice has to begin. We have not spoken about consent. Notice and consent are two different aspects again. Notice is how you are going to use it. Right? Sometimes you would have seen, no? CCTV camera. This area is under CCTV monitoring. That's a notice, right? Now, interestingly, there is a word called consent manager. I'll come back to this again. Significant data fiduciary. Again, I'll come back to this in a few slides because there are some context there. Last is the board. This is the government, basically, like how you have Securities Exchange Board of India, Insurance Regulatory Board of India. Under the data, we are going to have a board, Data Protection Board of India, established by the central government. This is not yet constituted, yet to be constituted. Investigation, inquiry, violation, penalties. These are the guys who are going to decide. And it is to this authority we are going to disclose in case there is a breach, right? So that means if I send one accidental email to Mr. A instead of Mr. B, will that constitute a breach? The answer is yes, provided you have sent personal data, right? First question. Second, will I have to report to the board? We do not know as of now, because if I read the law, it says any personal breach has to be disclosed. But is there going to be a monetary threshold for the, in terms of number of records, number of scenarios? That is something we are going to discuss, right? I think that gives us good clarity on the definitions. I'm going to open it up for a few questions if you have any, and then we will take the comment section.
Yeah, there are a couple of questions. Shall I read it? So Narasimhan, yeah, firstly, there is question that, okay, if there's a personal data, it talks about digital. So if people are keeping a printout of that, say, Aadhaar card, so does it still be applicable if that physical copy is, breached?
So the wording is very clear. Digitized version of the data is what we are focusing on. If you have a physical copy, no.
If you have received in digital and you take a printout and that printout is breached, so
bear in mind you said you have received in digital. That means
yes.
You have a digital copy yet.
Yes.
Data privacy is applicable. You have received it in digital. You right. Do whatever you want. You received a printout, not applicable in that context. In this particular context, let's say you have a physical copy, you misplaced that physical copy. It was written issued to XYZ bank for authentication purpose. You have misplaced that. The DPDP will not be applicable in this context because read that wording. It is digital personal data.
Okay, great, fine. Another question: generic email IDs such as webmaster at ISACA Mumbai, where you cannot identify that individual, but we know that few people could be behind that. 2 or 3 people could be using that email ID. So would it be identifiable?
A little difficult to define it as a personal data. Again, I would drive it based on the context. Now, for example, if you say support@facebook.com, how do you know who is support@facebook.com, right? Alternatively, let's presume you are a one-member company and you decide for some reason sales@abc.com, and I know everything will get routed to you, right? So you have to interpret it slightly contextual. You cannot generalize it, but if you ask me a generic answer, it is not identified with one particular person. Therefore, I will still call it as non-personal in this context.
Okay, fine. Now, if a personal data is publicly shared as per requirement of other laws, then how will it impact the data?
So, if it is something,
for example, GST number, like it is displayed in the offices itself at the entrance. Yeah.
So GST number is not a personal information. It is a corporate information. Please understand that. Right? Coincidentally, from a GST number, I can get to know PAN. Yes, I agree your statement, right? So by virtue of that, if GST is displayed somewhere and some fellow comes and takes a photograph of that, right? If he takes a photograph, digital data, right? It's applicable. He takes a written information, then probably different. But yes, there is a provision where it says somebody discloses publicly their personal information. In that context, it will not be considered as the consent requirements change. Is it still digital or personal data? I think we have already answered.
Okay, thanks. Yeah. So a personal chat on social media, WhatsApp, Instagram, between two people, two or more people, can we term that as personal?
It will be personal data. It will be personal data. But how well can you identify that this personal data belongs to whom? That's an interesting question, right? Assuming there is some, hypothetically, there is a leakage of this data, and I do not know who between ABC of one ABC name and XYZ name, this conversation is taking place. I am not able to get the mobile phone number. I only know the conversation has happened from ABC and XYZ. Again, look at the context where it has been leaked, right? If it is conversation India leaks in US for some reason, I'm not able to correlate, the impact and the penalty may be lesser. But is it a personal data? Yes. Is it a breach? Yes.
Okay, fine. Another question, how about Amazon giving encryption as a service to bank's cloud app? Will it be fiduciary or processor?
Processor.
Okay.
Amazon will always be a processor unless it is collecting your personal data for whatever XYZ purpose. Amazon will be a processor to the extent of their employee, and every person becomes a processor to the extent of their employee because you're collecting the personal data. And any other, no, let's say for example, you are submitting your personal records for the purpose of creating a account with Amazon. The question is, what is that personal records? You are entering abc@yourcompany.com. To that limited context alone, Amazon will be will treat this as personal data.
Okay. Another question, what if a person's under CCTV surveillance without their knowledge? Will it be a breach of their privacy? For example, in a public place or in a company lobby?
I will cover a notice and I'll cover that time.
Okay, fine.
Just wait for a few minutes. Because certain times CCTV monitoring is required for law enforcement. Why so much, sir? Your traffic signal CCTV, can you say that, boss, it's a violation of my privacy? The purpose of a CCTV there is for a legitimate use. So is it a personal data? The answer is 100% yes. Violation of privacy, I've still not come to the so many other elements of that. So I think I'll possibly stop for questions. I will cover the flow. I think some of your questions will get answered.
Yeah, I think all the questions on chat are covered by now. Yeah.
Thank you.
Elangovan, this is Sanjeev Deshpande, President of ISACA Mumbai Chapter. One quick question before you move further. Is there any concept of joint data controller, the way it is there in GDPR?
I would say yes as well as no, because let's read this particular thing, sir. Any person who alone or in conjunction with other person determines. So ISACA Bangalore chapter in conjunction with ISACA Mumbai chapter is determining.
Okay.
To the extent of ISACA Bangalore chapter, I am deciding along with you. To the extent of ISACA Mumbai chapter, you are deciding along with us. So both of us becomes a joint control.
Data fiduciary.
So we become in this context, in the Indian context.
Okay.
Good question, sir.
Okay. Thanks.
One quick question, Narasimhan. Since we are talking about the data protection, so obviously this will call for the data localization requirement, compliance requirements. Will you be covering all that?
Yes, it is there in one of the slides. We'll speak about it.
Okay, thanks.
Okay. Quickly on the applicability, simple answer. If you are processing digital personal data within the territory of India, applicable, full stop. That means what? A, you should be processing. You know what is the meaning of processing now? B, it should be digital personal data, and I think we already know what is digital personal data. C, you are processing within the territory of India, it is applicable. End of the story. Scenario number one. Sir, I take my digital personal data, process in Sri Lanka and come back. Let's read this. Processing of digital personal data outside the territory of India. What is territory of India? Again, you have to go to the definition of what is India, right? I'm not going to go to that level because, you know, I think 15 nautical miles from the Indian borders is also considered as India, right? Those are, again, I'm not going to that level of legal interpretation. I'll just go from a practical. Outside the territory of India, if such processing is in connection with any activity related to offering goods or services to data principals within the territory of India. TikTok app, assuming it is not banned, based out of whichever country, but the user base is here, DPDP will be applicable, and this is called as extraterritorial jurisdiction, a beautiful provision and much needed provision. You might ask, sir, how will I catch hold of TikTok in that case? Because I could not catch hold of him, I did a simple thing. I banned him. Yes, that's the whole purpose, right? Because if I'm not able to catch hold of that person, this happened even in case of WhatsApp and Twitter, right? WhatsApp and Twitter did not have a place of presence in India. The government wrote to them, if you don't set it up, we will ban you from this thing. And they requested the government, give us, a couple of months time, we will set it up, and they set it up, right? I'm just giving you context. Tomorrow, a new app comes, some dating app comes, some XYZ app comes, which is processing any activity relating to offering goods or services. You might say, sir, if it is free, is it goods or services? The law never spoke of consideration. Am I offering a service? Entertainment as a service. Dating is also treated as a service in this context. Messaging, communication, all of them will be treated as a goods or a service. So I think essentially this beautiful clause of extraterritorial will ensure that they are adhering to this principle. And when is it not applicable? I told you this example. If it is processed by an individual, that means one individual person, not a person. Look at this. It is processed by an individual for any personal or domestic use. That means for his or her own use. Right? It is not applicable. I gave you the driver's example. Right? Personal data that is made or caused publicly available by data principle or due to obligation under law. Somebody asked this question. GST I'm displaying. In that case, yes, it is not going to be applicable. Are we clear with this? In that context, you take that and you send him a message. Those are different scenarios, right? This is something which I sort of put across. First is, are you dealing with digital personal data? And next is, are you processing it in India? The answer to both of them is yes, directly it is applicable. So there's no questions about it. Next, you are dealing with digital personal data, and if you are processing, the answer is no, no other, directly not applicable. You have digital personal data, but you're not processing. But again, look into it. The word processing is very interesting. Even if you're storing the data, it becomes applicable, right? So technically, the last scenario is very remote. Now, you're processing in India, the answer is no. That means obviously you're processing outside India. So when you're processing outside India, look at this wording, the answer is yes. Is it for offering goods or services to a data principle in India? The answer is yes, it is applicable. If the answer is no, it is not applicable. One of the popular questions which I keep getting, GDPR or DPDP is applicable only if I'm an Indian citizen. I don't think so. Why? It says, are you processing in India? It did not say that the data principle or the data subject, however the wording is, should be a resident or a citizen of that particular country. That means if Mr. XYZ from US, UK, whatever country comes to India and he is checking into a hotel in India, right? Digital, and he is scanning their passport, digital personal data, yes. Are you processing in India? Yes, applicable. End of the story. Now, an Indian citizen is going abroad. Look at this very interesting thing. An Indian citizen is going abroad. Look at this very interesting conversation. Now, he is booking an online reservation in XYZ hotel. Where? Whatever XYZ hotel in US, UK, whatever. But he is booking such details and they are electronically capturing that fellow's details. So are you processing in India? The answer is no. But are you processing in India? The answer is yes, right? Processing outside of India, my hotel details. But is it for offering goods or services in India? The answer is no. Therefore, that hotel need not comply with the requirement. I'm talking about an Indian person or an Indian going abroad for stay. However, I just complete it, sir. Give me a minute. However,
sorry.
However, now the same hotel group is there in India as well as abroad. Now that hotel group gives a loyalty point in India, and he says you can avail the services in my Indian hotel chain. It is for offering goods or services in India. Therefore, that hotel in US is to comply with the Digital Personal Data Act. There is no registration requirement. So bear that in mind. It has to comply with this. How will it comply? It depends to the extent of that one passenger. We have to look into it, right? Please bear in mind, this is only processing. Okay, interesting question Sunita is asking. Does the location of server matter? Silently, let's look into this scenario, right? It's not explicitly mentioned in the law. Are you processing the data? So that means Amazon server, look at this beautiful, thanks for asking this question. Amazon server is hosted in AP1 West Coast, right? Availability zone, whatever. So somewhere in US. Now that Amazon server, right? Are you processing in India? No, right? But is it offered for goods and services to a data principal in India? Now Amazon is not doing it. You as an organization are storing it, right? So be a little cautious. Amazon does not know what data you're storing there. So to the extent of Amazon, right, it may not be applicable. Just because you are storing your personal information of your customers in US, it doesn't mean that Amazon has to comply with the DPDP. But if you are storing it in US and you are in which case collecting in India, so therefore it has to in which case be applicable. However, Amazon is storing your individual information to that extent or that context. It becomes a little tricky scenario to the extent of Amazon collecting your personal information, right? To that extent, I would probably say yes, it applies because Amazon is renting that services, right? So this is one of the key reasons, or this is one of the key reasons. Somebody was asking me, sir, is there an element of data localization? Indirectly, people have started interpreting this, hey, because of this clause, we may have to think of data localization. We may have to think of data localization. By the way, between India and other countries, data transmission is allowed freely, right? Except a negative list. Unlike a Europe is a positive list. That means only in these countries you are permitted to share the data. India has not done that. India said in all countries I'll permit excepting the following list. What is that following list? We do not know. It is yet to be notified. Maybe it might say Afghanistan, Bangladesh, whatever, for various reasons, right? And please bear in mind, the principle of data localization is not given here. You have to read it from here. Plus, you have to read under the respective law, RBI, IRDA, SEBI, Companies Act. These are indirectly talking about data localization. RBI says all financial data in India, full stop. Insurance also, IRDA also says that. SEBI also is saying that. However, when you look into Companies Act, they did not say that all the financial data should be stored in India. They only said all the financial data should be accessible from India at all times. The Companies Act last year, August 23, they amended it. And the backup has to be in India only. Companies Act says the backup of the data has to be in India and daily backup has to be taken. Daily backup has to be taken of financial data and the data has to be only in India, right? So that's this thing. One popular question they will ask, sir, DPDP is saying one thing, RBI is saying another thing. Which law to follow? A specific law will override the general law. So DPDP will talk about in general. If there is a stricter compliance of RBI, we will follow that. Clear? Going to certain key provisions. How can I process data? I have received personal data. How can I process it? And I hope you know what is the meaning of processing. Just to reiterate, collection, recording, organization, structuring, storage, alteration, transmission, combination, alignment. Look at this: transportation, dissemination, restriction, destruction. Again, all of this in relation to personal data. Don't forget that. Sir, my vendor is doing all of these services. Please check, is he doing personal data? If he's not doing personal data, don't bother. So always have that in my mind. First filter is he personal data? Is it digital personal data? Then think about everything else. And interestingly, the law said digital personal data only because the misuse of digital personal data is way higher than a non-digital data. I have Aadhaar card, Xerox copy. How much can I do analysis? But if I have that in soft copy, I can do so many analysis, right? So I hope you're able to get that context. So what is the grounds of processing? Means when can I process personal data? The personal data can be processed personal data of a principal can be processed only under 2 scenarios. For which the principal has given her consent. And remember the wording her, I told you in this law, her, him, he have to interchangeably used, right? When the data principal has given her consent or for legitimate purposes. This legitimate purposes is where your CCTV camera, somebody asked me a question, right? This will come under that. I'll bring up during that point in time, right? Personal data of a data principal in accordance with the provisions of the Act for a lawful purpose. That means which is basically not prohibited, right? Provided the principal should have given consent. Now we are talking about 2 scenarios, right? Again, I'm going to reiterate it. First, we spoke about what is digital personal data. I think all of you are clear with this, right? What is DPD? Now, this DPD is collected by whom? The fiduciary. Whose data do I collect? Principal. Now, when can the fiduciary process? And we know what is the meaning of processing. We know what is the meaning of processing, right? So, when can a fiduciary process the data? If and only if the principal has given consent, or principal can still process for certain legitimate uses. For legitimate uses. I hope you're able to clear. Just to re-emphasize, repeat. First, we spoke about what is data, what is personal data, what is digital personal data. Then we spoke about applicability. Now, given these 2 scenarios are met, we are talking about when can I process this personal data. It is possible in provisions of this Act for lawful purposes, provided the principal has given consent. That means consent is very, very important. Consent, what is required? Just to wait and talk about it. Or legitimate uses. So legitimate uses is a very interesting wording, and there are a lot of GDPR related judgments which you can probably go and interpret it and look into it whenever you have time. But let's look into each of this. Just give me a minute, please. Are you finding the discussion useful? Are you finding the discussion useful? By the flow, am I not? I hope I'm not too fast.
Yes, definitely. And
Everything
yes,
is okay, right?
upon the consent, there is a question.
Small question.
Consent has to be specific, or it can be in a policy?
Consent, I will just discuss, sir. Give me some few minutes, sir. Please. Consent, I'm just going to discuss. Every element of your question, I have thought through and have put it in that flow.
Great.
Right. So I'm mostly see, tomorrow I have to implement this for my clients. Right. Tomorrow I'm going to I'm sure all of you are going to implement for yourself, your organization, or for your clients, right? So I thought from that angle and I've just given the logical flow. I'll take your question. Thank you so much, everybody, for the quick feedback. Mr. Iyer, I think you had a question.
Legitimate word, is it not?
That is a separately given. That's a separately given. We will discuss that also. Right. So for this also there are scenarios. For the right hand side also there are scenarios we are going to discuss. Okay, quickly moving forward. When can I go for a consent? Right? When can I go for the consent? That means we are trying to cover which scenario, my dear friends? The first scenario over here. We are trying to cover this first scenario where the principal has given the consent. So what is the requirement of consent? What is the requirement of notice? The data fiduciary, that means the person who is deciding the means and purpose, should provide a notice. And notice, you can, for all practical purposes, you may treat it as intimation. Now, interestingly, it said as may be prescribed. So we are expecting the law to define what should be the content of the notice. However, general parlance, we can infer so many things. We will address that. Right? So that means a fiduciary should provide a notice and the principal has to give a consent. Only if this handshake is done, you can start the process. I repeat the statement. First, fiduciary has to send a notice. Second, principal has to give a consent. Only if this handshake is done, you can start processing. If this is not done, no processing. If there is no processing, nothing you can do. Remember, storage of data is also processing. So which means here data fiduciary is not given notice. Data principal is not given consent. Can I store the data. I'm not using anything. Not possible, sir. You are unauthorized to have that. I hope you're able to get my statement very clear, right? So we spoke about notice, we spoke about consent, right? Now, what should be there in the notice? What should be there in the consent? One level down. Consent should be free. That means I should not forcefully ask you. It should be freely given. First. Second, it should be very, very specific. It should be very, very specific. And it should be informed. That means the person who is giving the consent, he or she should be informed about what you're going to do. It should be unconditional. Very interesting. The consent should be unconditional. That you cannot say, I will give you my consent only if you do this. No. It should be unambiguous. That means very, very clear. Consent should be affirmative action. And last, it should signify an agreement to process the data. Look at this wording. And if you just look into this consent requirements, you'll go mad. Already, I think your mind has started thinking on so many scenarios, right? How it will apply in my organization. And if you are doing it, I'm very happy because you're actually putting it into use. It should be free. It should be specific for a purpose. It should be informed. No conditions. Unambiguous. Clear affirmative action and signify an agreement to process. So I hope consent is clear, right? We'll discuss smaller nuances on consent. We'll just give you a minute. And for obtaining the consent, you have to issue a notice. Remember, consent, notice plus consent is a marriage. And the marriage is for what? Processing. I hope you're clear. Notice plus consent, only if they marry together can the processing happen. In this context of DP. Earlier we used to call PDPD, right? Whatever, all those fancy names, personal data protection. What should be there in the notice? What should be there in the notice? Details about personal data that should be collected. What is the personal data of yours I'm collecting? Name, Aadhaar, bank, whatever. You mentioned it. Why am I collecting that? Third is a very, very important rights of the data principle. Tomorrow I am collecting your personal data. What rights you have on me to the extent of personal data? And tomorrow you as a data principal notice that I am misusing. How can you complain to the board? Are you understanding? Currently, under the Information Technology Act, some of this are indirectly covered. Some of them are indirectly covered. Details about the purpose, rights, and a manner in which there is no, the last point is obviously not applicable because we don't have a code. But in general, they have given the first and two. Rights have not been spoken under the requirement of the existing consent under the Information Technology Act. Right? So details about personal data, purpose for which it is covered. Now, interestingly, when you obtain this consent or notice, they say it should be in English or any language specified in the 8th schedule of the Constitution. I think there are about 20 odd languages you can probably mention. You can obtain any of them. So regional language also you can. Now comes a very interesting question, sir. What if I already have taken consent or I'm already processing personal information? This is where the second point comes into picture. You still have to issue a notice as practicable as possible to the data principal when the consent was obtained before the commencement of the act. As much as possible, the moment the act is notified, you need to give a notice and you need to obtain a consent. This is like cleaning up your old पुराना पाप को क्लीन करने का mechanism. पुराना पाप को clean करने का mechanism. Are you clear with this? Such data can be processed till such time the data principal withdraws the consent. That means unless he is withdrawn the consent, you can still keep on processing the data. Are you clear with notice and consent? I have few more slides on this. We'll discuss on that. And then I'll open it up for questions. So this is a summary slide. If you ask me, what is the meaning of consent, right? What does consent imply? It should be clear, affirmative, and ambiguous. That means individual should give consent by clear, affirmative actions. Yes, I agree. If it is silence, if it is pre-ticked box, if they do not do any activity, it does not amount to consent. Look into most of the websites today. It says by you visiting this website, you hereby agree to our privacy policy. No, that is not an affirmative consent. The consent should be informed. That means the individual should be aware. So that means every individual has to read that policy. It is their choice. At least you put a tick mark that I have read the privacy notice, and next box, I hereby give my consent. So 2 boxes. And my suggestion is whenever you're implementing this consent, that box exercise, capture their IP address and the date and timestamp under which they are capturing the giving you the consent, because tomorrow in case of an enforcement, you will have to prove that. Individual must be aware of the controller's identity. What is the purpose? And how can he or she withdraw the now specific. Consent cannot be hidden in the privacy policy or terms and conditions. It should cover all processing activities for the given purpose. If there are more than one purpose, this is what is a very interesting thing. Consent must be given for each purpose. This is going to be very difficult to implement. This is going to be very difficult to implement. And you cannot have a bundled consent. Right? Again, is the law very, very specific on this? These are all interpretation of the global scenarios, but this is how you actually interpret it. Right? Freely given must be genuine, free of choice. Consent not valid when there is a clear imbalance between the individual and the controller. I do not know who's doing what, etc. Presumption that consent was not freely given. Individual is not allowed to give separate consent for different activities. Right? And it is not necessary on performance. I told you this has to be very, very clearly articulated. So I hope all of you are clear with the expectations of notice and consent. We'll come to this, whether there's a right to delete or erase the data. We'll come to it. The simple answer is yes, there is a provision. However, you can still retain if there is a legal requirement. That's a different scenario. For example, the bank. You can perform a transaction with a bank and say the bank, you know, this is my personal data, delete it. Bank is not bound to delete it because the Prevention of Money Laundering Act clearly says for 10 years, every record of a bank has to be maintained. So that will override. And it may, when you say bank, insurance, cybersecurity, fintech, whatever space, right? The Prevention of Money Laundering Act will have a slightly overriding effect. Likewise, the Companies Act talks about 8 years. Right? I think I've given enough of illustration. So this is there in the act. So I'm not going to go into that. Withdrawal of consent. The data principal, that is you and I who have given consent, and we have option to withdraw the consent at any time. Somebody was asking, right? At any time. Such withdrawal shall be similar to the ease at which consent was given. This is the most important thing. Right? It is like Chakravyu. To enter, it is easy. To exit, not possible. Nahi chalega. To exit also, it should be easy. That's the beauty what the law says. And upon withdrawal of consent, the data principal is required to cease and cause its data processes to cease processing the personal data within a reasonable amount of time. This is what is interesting. So I have taken back the consent from principal. So the principal has to inform the processor also to delete it. Example. I am using a mail service provider for sending emails. MailChimp. I think many of you might be using it, right? MailChimp is a processor. You are a data fiduciary. So somebody said, hey, you know, do not contact me. I unsubscribe. So you are getting the intimation. So therefore you have to delete it. And you have to inform MailChimp to also to delete it. But obviously a MailChimp will say, boss, if 1 lakh people keep on asking me, I am not going to do that. So what is the way out? MailChimp will give that feature to you for you to go ahead and delete it. Right? So this have to be very, very carefully interpreted. one of the most draconian provision is the last line. Non-compliance by the processor will be considered as non-compliance by the fiduciary. I repeat that. Non-compliance by the processor shall be treated as non-compliance by the fiduciary. I'll give you an interesting scenario. Starbucks, McDonald's, Domino's, all these operate on a franchisee-based model. The data, how these franchisee models work is, it is given to Mr. X or Mr. Y or XYZ Private Limited to run the business. But the software, data resources, the style of manufacturing, making, all of them is driven by Domino's or McDonald's or KFC. So if you are getting an offer or a message, right, normally 99% it is Domino's who's sending that message. It is not the Domino's franchisee owner. But tomorrow the franchisee owner misuses the personal data. Franchisee owner misuses the personal data. Domino's will still be held liable. Non-compliance by the processor will be considered non-compliance by the data fiduciary. Example 2. If the third-party administrator does some non-compliance, the insurance company can be held liable. Now look at the game. The game is changing here, my dear friends. Corporate game is changing. Now fiduciary and processor, the game is changing, which means fiduciary is going to put heavy requirements on processors going forward. Heavy requirements. Be very clear. Don't think, oh, I am a processor, therefore I am not bothered. Your fiduciary will ensure he will have right to audit clause. He is going to be very, very, very clear that he is not going to spare you as a processor. Be very, very careful because of this draconian provision. I hope you are able to understand this, right? Going back to what I spoke a little earlier, right? First we spoke of principle and consent. I think we understood this particular clause. Now there are certain legitimate clauses where you will always be thinking, hey, what is legitimate? That is where the law has defined, right? What is legitimate? I'm quickly going to this particular slide. What is a legitimate use? When data is voluntarily provided by the data principal. Data principal voluntary comes and says, here is my data. Then you can use it the way you want, right? Voluntarily provided. Data principal has not indicated, does not consent to use of personal data. That means he does not say, I am not okay with it. Indirectly, he is giving a consent. So therefore, you can still legitimately use this. It's a little bit of an interpretation of it. By the state and instrumentalities for the timing. So the state can use your data whatever the way you want because of the exemption. For matter concerning public interest, now medical emergency, you are admitting somebody to hospital. Hospital asking your Aadhaar card. At that point of time, consent is obviously not possible, right? Similarly, judicial use, criminal proceedings, pandemic, right? So those will obviously override. Last, very interesting point, a big boon. For the purpose of employment is treated as legitimate use, or for those relating to safeguarding, the employer from the loss or liability. Now you have a CCTV camera in your office. If you are able to meet the requirement of 5, you need not take a separate consent. Right? But it should be in a legitimate place. You cannot keep it in every possible place in your office. Maybe 1 or 2 places, it makes sense. Right? So look into any of these scenarios, now think, right? Is it a legitimate use or is it a consent based? If they have given consent, nothing doing, go ahead. If it's a legitimate use, you can go ahead. So 2 scenarios, you can process the data. I hope it's clear. So just to summarize, we understood what is data. We understood digital data. Sorry, we understood data, personal data, digital personal data. Then we understood applicability. Then we understood the 2 people, data principal, fiduciary, processor. When can we understood the meaning of processing. When can we process the data? It can be processed only based on legitimate use or based on consent. How do you obtain consent? Based on two things. Notice marries consent, you can process. Who issues notice? Fiduciary. Who issues consent? It is data principal. I will just pause a minute over here. How much more time we have? We have about 20 minutes, 30 minutes.
Yeah, half an hour. Yeah.
Okay, thank you. Okay. Any questions at this point in time? I'll probably take 2 to 3 questions, and I hope you are able to.
Yeah, I think there are a lot of questions, but almost all got covered, by your explanation. That was good. Yeah. Just yeah. Now this regarding permission, like we see for many events, there is a permission that you agree to share your details with the sponsors. If this tick is done, and what the sponsors are going to do with that.
You have to define in your privacy policy. Only then after that you will have to get that. Otherwise, your notice is invalid. If your notice is invalid, consent is invalid.
So we should also be writing what the sponsors are going to do with that data.
Yes, very important. For example, I think this happens in many of these events where what do you call the sponsor or whoever is the company, right? They are going to ask boss, I want the attendee list, please give it to me. Right? Very interesting this. So you should in your privacy policy mention clearly that I will share this with my sponsors and they will contact you for the following purposes. Right? To that extent, if they contact you, it is legitimate use. Sorry, it is accepted use, consent-based use. If they do it outside, you cannot. Now let's take another example of a legitimate use, right? Again, this is the legitimate use is just a few examples. You can have other legitimate uses also. Say, for example, you have registered some person for a webinar, and all of them are because you gave an example of an event, right? And for some reason that event was cancelled. Now you are calling up all of them and telling them, sir, this is cancelled or this is rescheduled to this day. Would you like to? Now that time somebody cannot say, boss, how can you call me up and say you do not agree for me? It is understood as a legitimate use. Right? So the word legitimate use has to be very slightly carefully interpreted is what I'm trying to say. Is this the only legitimate use? No. GDPR has got a very beautiful guide on legitimate use. Good piece of discussion. And by the way, there is a website called ICO, Information Commission Office, I think of UK. Lot of analogy discussions are taking place there. Whenever you have a conflict, you can always refer that because you will get an idea. It's not that exactly we will use it, but you will at least get an idea.
One question.
Yes, Mr.
Narasimhan, does it talk of anything on the enforcement and the penalty part?
It is there, sir. It is there in the presentation. It's covered here. We'll cover that.
Yeah, sir, I'm Vishnu Kanere. I had one question, if you permit me.
Please go ahead. I'll take one question and then I'll go.
Yeah, okay. See, you have mentioned, the Act mentions about informed consent. So my point here is because informed consent in other contexts has been made to interpret that the other person has clearly understood it. I'll give you an example. In Europe as well as in the EU, whenever any complex investment product is sold or offered to an investor, then that investor is categorized or they have different categories. So one is a professional investor who has basic knowledge of investing. And so then in that case, a mere consent is sufficient. But in the other case of lay persons, whoever is obtaining the consent has to demonstrate that the other person has really understood it. Now, what are your views on informed consent under this Act?
I'll probably put it this way. In your example, the person is giving a consent for not using his or her personal data, but rather for achieving the business objective of investing or not investing in a complex derivative product. Right? In this context, consent will not be driven from the data privacy law, it will be driven from sector-specific regulation. And what is this? What is the sector-specific regulation? It could be SEBI or whatever this thing. Allow me to complete.
Understood.
Allow me to
Yeah.
complete.
Okay.
Scenario number 1. Scenario number 2. The law only says informed consent. They have not further gone ahead and classified. Now, what is informed consent? That is interpretation. Say, for example, a person did not even know English, but somebody has asked him to put a tick mark and therefore he is given the consent. It becomes a tricky scenario. So tomorrow you are collecting some data from a rural folks who is not aware of the English language. In that case, your consent has to be in that particular local language. For example, there are a lot of loan apps which are there, which collects the data from rural folks. In that case, the consent should be from that language. Now, how do I demonstrate? Have I read through everything? That's an interesting question. Legal interpretation will come into place. But from a processor perspective, I have seen some of the banks, what they do, some of the banks, right? Unless you scroll down their policy towards the end, that I accept button will not get activated, right? So these are all technology initiatives which you can consider doing. In the interest of time, I will complete it and will take your question towards that. I hope that's okay.
Yeah, sure.
Right?
May I just ask one question, please?
Yeah, one last question, please, because we are running short of time. Yeah.
What about data which is taken from public domain, like Google listings and all? If we take that data and process it, is it? Do we require to take consent again?
Question is, I would still say consent is required, but you can still store that. I mean, go back to the definition of processing, go back to the definition of consent, and go back to you trying to reach out to that person, right? So if you go back over here, voluntary provided personal data, no problem. But you are taking something from public domain. In that context, it does not even get categorized as digital personal data because the exclusion of the law comes into picture there. Right? So in that context, it's a little bit of a dicey situation where I take the data which is available on Google, or somebody, while blogging shared the personal information, and I'm taking that personal information and contacting them. I think your digital personal data will not be applicable in that context. The law specifically gives an exclusion there. But how long can I go ahead and do it? Again, I'm sure, in days to come, that gap also will get closed.
Thank you.
Okay. Again, just to reiterate the difference between fiduciary and processor. Fiduciary, or also referred as controller, the entity that along with others determines the purpose. That means why am I processing and how am I processing. The processor is merely following the instructions, right? And we already know who's the data principal, who is nothing but whose personal data we are processing. What are the rights of the principals? First, grievance redressal. So if you have any grievance, if he has any uncomfort or any questions, there should be a grievance redressal mechanism, right? Right to correction and erasure. Somebody was asking this question, is there right to erasure here? The answer is yes, right? Suppose you are storing some incomplete information, you are giving an intimation, you are supposed to correct that. Right to nominate. Individuals can nominate any other individual to excise. This is for the first time a power is there. In the other regulations, explicitly this power is not there. Inference is there, right? For example, in case of a death or in case of incapacity, you can nominate somebody else. Right to information. This is again available. This is also called as subject access rights in some of these foreign regulations. Individuals have a right to seek more information as to how their data is processed, right? So this is the data of rights of principle. Now the principle also has got certain duties. Interestingly, he shall not impersonate another person. Who is this? You're talking about the principal. He cannot impersonate another person. Not to suppress material information or proof of identity, not to register a false grievance complaint. This happened in GDPR actually. A lot of people, they used to blackmail the company saying that we'll go ahead and complain if you don't do this. And they prefer to enter into a settlement outside rather than going via court or the authorities, because the name, brand, other things matter. So be a little cautious. Furnish only such information which is authentic while exercising the rights. In case of failure to do this, a data principal also could be subject to a penalty, and that penalty is around roughly about 10,000 rupees. Now comes fiduciary obligations. Please remember, obligations means you must do it, no other question. First, engage with the processor to process personal data based on a valid contract only, which means no contract, nothing you can process. Please be very, very clear. Please be very, very clear, right? I'm sorry. Yeah. Next. Obtain verifiable parent consent. Look at this, verifiable parent consent before processing children's personal data. It's a very interesting game. I told you how do you verify who is the child, who is the parent. Tomorrow, do not be surprised if they ask for these child education apps, that they ask to prove that this is the child, this is the parent, and show me the verification. Right? So that's basically how it is. Report personal data breaches to the data protection board and data principals. Very important. Inform the government or the registrar or the board, also to the principal. They have not yet notified what is the threshold limit, right? So we have to see that. And provide a clear data. We spoke about notice. Delete or cause its processor to erase the data. Abstain from processing personal data that may cause harm to children, or anything relating to behavior monitoring of children. Very interesting. Anything relating to behavior monitoring of children is prohibited. Anything relating to targeted advertising of children is prohibited, right? Some of the Indian television advertisements are targeted only for kids, so that they will actually go and subscribe or do that, right? So if you are doing it on a digital front targeted to a specific community, it is prohibited. Implement, very, very interesting. Implement technical and organizational measures. They have not mentioned what these are. This is where all your security practices comes into picture, right? If you look into GDPR, I think Article 30 or something, they mentioned technical and organizational measures. You can refer here. In Indian context, they have not mentioned anything. Now, this is a variation of a data fiduciary. It's called as a significant data fiduciary. That means the next level of fiduciary, right? A significant data fiduciary, based on the central government notification, they will identify such category of persons as significant data fiduciary. Who are this? Even I do not know, even you do not know, even the government does not know as of now, right? But they have told what are the factors which could determine a person as SDF. First, volume of the data and sensitivity. This is the first time the government has used the word sensitivity. Repeat, this is the first time the government has used the word sensitivity. Please excuse me. Just got a cold, so please excuse me. Sensitivity and personal data, right? Volume of and sensitivity of personal data process is one factor. Second, the risk to the rights of the data principal, potential impact on sovereignty and integrity of India, risk to electoral democracy, very interesting thing, electoral democracy, security of the state, public order. Right? So these are the factors which could determine. As of now, whatever you imagine could be right if it falls under this bucket. So election commission, electoral data could come under this. Police records could come under this. Anything relating to security of the state could come under this. So these fellows are called a significant data fiduciary. To my sense, all the banking companies, insurance companies would come under this because of certain reasons. Security company, security or security, cyber security market companies may get classified. We'll have to see how it works. Whether a company becomes a SDF is something which you have to very carefully determine. But definitely banks and insurance will fall under this. That much I'm very sure. Other players will have to see, right? And if you are an SDF, what happens? That is the next question. You need to mandatory appoint a data protection officer. And there's a lot of provisions of data protection officer. In the interest of time, we're not going to so much into the detail. Appoint an independent data auditor, professional opportunity, independent data auditor to carry out data audit. And what he should do, he shall evaluate the compliance of SDF in accordance with the provision of Act. So whether he is adhering to this. And he shall also perform periodic data protection impact assessment. So DPO is mandatory only for a significant data fiduciary, otherwise not mandatory as per the current legislation. Notification, something else comes, we'll have to see, right? I hope it's clear. Data protection impact assessment, DPIA, they have not told what is a DPIA, but basically it's like a risk assessment and understanding what are the types of it, because they have not told explicitly, but they have mentioned what does a DPIA is supposed to do, which shall be a process of comprising of description of rights, the purpose, personal data, assessment, management, I would say a complete risk analysis, right? And a periodical audit. So these are things which is, I think, requirements of a significant data fiduciary. A few special points. on breaches. What is breach? I think we have already spoken. Unauthorized processing, sharing, anything which compromises the CIA, right? The data fiduciary or the processor have to notify the board. We spoke about this. What is the personal data breach, right? It is required, say for example, required protection was not done. Even the processor has done some misuse. Processor has not taken reasonable security practices, right? All of those. There's no specific timeline as to how quickly I need to report the breach, right? But there's going to be a prescribed form where all of these details are going to come up. DP board, I think the central government is going to establish a board as a body corporate, which has the powers, etc. Civil courts, interesting, civil courts are barred from entertaining suits. So it will directly go to the board and it will have an empowering to adjudicate under the DPDP, quite similar to that of SEBI or IRDA. The board will function digitally. Very, very interesting. Very, very interesting. For the first time, the law itself has said the board will function digitally. That means it is basically saying we want faster mechanisms, right? So this becomes a professional opportunity for those in this field. They will, be digital design in terms of receipts of complaints, hearings, pronouncements, everything is going to be electronically done unless there has been some challenges, right? So that's an interesting legislative. Next, very popular question people ask is retention of data. How long can I retain the data? The fiduciary must erase or cause cause its data processor to erase as soon as you receive the withdrawal request or the purpose for which it is no longer necessary is over. Say for example, you are giving your Aadhaar card or a driving license copy to a hotel. The hotel is expected to delete after a reasonable time. Now, if they have not defined a reasonable time, you go back and search what is the police records or what is the purpose of the hotel retain. The hotel may have to give it to the police or law enforcement agency tomorrow if there's an investigation. So they have to retain for a reasonable time. What is that reasonable time? Do not know. We have to see, right? Or some other law, unless a restriction is enforced. Like for I told you, prevention of money laundering says 10 years. Cross-border transfer, I think I already make a mention. Central government to restrict the transfer of personal data by fiduciary to notified countries. That means to these countries, no transfer. That means you can go ahead and transfer everywhere, right? Transfer will be permissible to all countries until any of them are blacklisted. However, sectoral laws, I think already spoke about RBI, SEBI, etc. This is a very interesting provision, concept of a consent manager. For the first time, a concept of a consent manager is not there anywhere in the world, but people are there, but it is not formally recognized under the law. In India, they have recognized as a law. For example, I know one company by name One Trust. They do this consent management, but here it's going to be a little more different, right? This is going to be quite similar to that of your KYC intermediary. So if you have authenticated your details with one KYC intermediary, the bank can obtain all the details from the KYC intermediary. So you need not submit KYC everywhere. That's the provision currently. Not everybody follows, some of them follow. So same way consent manager could be there, but it's going to be a lot of challenge. But again, an interesting provision. He should be registered with the board. It becomes a single point of contact for the principal to give the consent. So it could be there could be a scenario where consent managers for all banks are routed through it. Example, right? It is accessible, transparent, interoperable platform. That means, all these interesting things. The consent manager itself may become a significant data fiduciary. You never know, right? So data principal may give, manage, review, withdraw consent to data fiduciary through a consent manager. So a lot of technological elements are going to come. How the consent manager is going to transmit this information. A lot of questions are going to come up. But consent manager is accountable for the data principal. So please bear that in mind, right? So there's a new provision, new interesting business model is going to come up, and obviously it's going to have its own advantages and disadvantages. Person with disability, right? I think I already spoke of. In case of children or in case of person with disability, you need to mandatorily take the consent from the guardian or the parent, right? That's a very, very important. Consent manager is not mandatory, it's an optional provision, right? And who has a lawful guardian in the form of prescribed. Okay, by the way, session is not yet over. Just give me 5 more minutes. I'm wrapping up. I'm seeing a lot of applauses. I know we are interested to wrap it up. Just give me a few more minutes. Organization may put up measures to authenticate, verify the identity. I told you, you can ask them to upload birth certificate or a passport, or how are you saying this person is disabled and you are the legal guardian. It could be certain things like that. And you are prohibited from processing the personal data of children, which could have detrimental effect to a child. I think I already spoke about this. And of course, penalties. Breach in the obligation of data fiduciary, 250 crores. Not giving a notice to a principal, 250 crores. Right? Breach in observation or additional obligations relating to children is 200 crores. Significant data fiduciary, 150 crores. Any other provisions of this act, 50 crores. And the lowest penalty is 10,000 rupees. That is for violation of obligations of a data principal. So data principal does frivolous complaints or does some bit of time pass or unwanted mischief. He could also be penalized. Data principal. Last section, some interesting insights which I sort of gathered up. Again, some of them are research, some of them are picked up from some sources which I've just mentioned them. Employers, interesting thing. One of the first thing you have to bear in mind is when an employer do have to take consent, right? The consent is necessary if it is employment related, providing employment benefits, or you are doing something to prevent you from mischief. So you're collecting the PAN, Aadhaar card for safety purposes of for preventing mischief breaches, then okay, right? If there is a legal right, if there is something which is entered as an agreement, etc., then you're okay. Otherwise, if you are doing background verification, health check, etc., then you have to take specific consent. That is the summary of this particular slide. If you're using AI-based intelligence for your systems, the act, this particular scenario is applicable only if you are scraping public data, no problem. From third parties, brokers, etc., you are trying to obtain, then again see whether these people are having a generic based information. If they're having personalized information, again go based on their consent. So that's the obligation. I think most of it we have discussed. The last few slides, many of them are asking difference between GDPR and DPDP, right? So GDPR applies to processing of personal data wholly or partly by automated, whereas in DPDP, it is only clear, only digitized data. Non-digitized is not considered. So in DPDP, your Aadhaar card or your passport copy, in GDPR, physical copy is still personal data. In DPDP, it is not because it's digital. Penalties, obviously, there's a difference. Children, I spoke about it. Breach should be reported within 72 hours in case of GDPR. In DPDP, they have not mentioned. It is going to be specified. And if you have a subject access request, GDPR gives 30 days. In DPDP, again, it's not mentioned. You have to be specified. GDPR talks about if I have to transfer data from European countries to others, there is something called BCR, binding corporate rules, or standard contractual clauses. These are the only two methods. Earlier, I also had privacy shield. The privacy shield is now annulled, right? So GDPR has only about two methods. In DPDP, nothing is specified. So I think it might probably come up over a point in time. Controller and processor have to appoint DPO in special scenarios, and when they're processing significant data is what they use. In DPDP, only a significant data fiduciary has to appoint a DPO, right? So I think that could be a context. Data controller and processor, ROPA, which is record of processing activity, GDPR you have to maintain. In DPDP, it's not required. GDPR does not explicitly specify provide notice to regional languages. DPDP says you need to have, based on schedule 8 or whatever, 22 Indian languages. Does it mean that every fellow has to provide? It again depends on your audience, right? And DPIA has to be conducted by data controllers, whereas here only they use the word high risk processing activities. In DPDP, they use the word significant data fiduciary. So I think is the wording and positioning. So the last part of the discussion, I know I have about 7 minutes. Please give me at least 5 minutes. I'll wrap this up and keep it open for Q&A. What is it that I need to do, right? I think a whole bunch of what you see in this slide is what you need to do. Yeah, Rohit, I'm trying to go as fast as possible. Conduct a data audit, right? Start looking into your policies. Implement very, very, very strong data governance. Very, very, very strong data governance. Obtain valid consent. Enhance data security measures, right? Develop data breach plan. Conduct employee training, very important. In case there is a subject access rights, develop a procedure. Vendor management is now going to become very, very clear, right? And probably, stay updated with legal advice. That's where people like we are there, where, obviously we keep sharing our thoughts. But that's not the end of the story. You know, you need to keep yourself updated. So if I have to summarize, we're speaking about digital personal data. We spoke about cross-border. We spoke about personal data and breaches. We spoke about rights and duties of principals, and of course, the obligations of fiduciary. Notice and consent, very, very important. Compliance, processing of certain legitimate uses, significant data fiduciary, we spoke of that, right? And some bit of voluntary undertaking and those related provisions. So if you ask me, this is an interesting piece of legislation. For the very, very first time, we have come up with some regulation. There are going to be a lot of teething issues, but I think look yourself 3 to 5 years down the lane. As a country, as a company, am I having a good data governance? I think this act is the first step for that. Thank you so much for being a very, very patient audience. Happy to be in touch with you. You could feel free to, you know, connect with me on LinkedIn. That's my LinkedIn QR code, or Narasimhan Elangovan. You can just type on LinkedIn. You will be able to reach out to me. Part of the Grove Senior Advisory Team in providing digital security services.
Mr. Narasimhan, I think it was a wonderful session and very good insight you could give.
Thank you.
But since it has not been notified, when do you feel the individual organization should
Very
start?
tricky, sir. My suggestion is start at the earliest, because you never know when they could notify, right? Point number one. Point number two, I think we have elections around the corner in probably 6 months to a year, 6 months time. So things would slightly change. I would probably keep it a little subjective. Maybe some are arguing that it could happen after the elections. We do not know. But my sense is, you know, don't let time. I think it's time to do the assessment and keep your practices and things ready, because tomorrow we may have to do on a war footing basis. It becomes very difficult.
So preparatory
obviously consultants like us will become very busy that time.
A lot of new opportunities will also open up.
That was a very informative session, Mr. Elangovan. Thank you so much.
Thank you. Thank you.
Thanks a lot.
Thank you.
Thanks a lot.
Thank you. Very
Yes,
nice.
Thank you.
Thank you so much.
Very nice. I'm seeing at least about 140, close to around 140 odd.
Yes. So we were
That's very nice.
150. Yeah.
It was 150. Yeah, I'm sure, you know, people have just moved out.
Yeah. Yes. So of course, a very amazing session, Narasimhan. So very, very insightful. You have covered, you know, very much in detail the act, you know, which has come in less than 3 weeks now, and with lively and nice examples with humor. Okay, so also knowing that, great to know that DP Act is applicable to Lord Balaji as well. And judicial history you have covered, international as well as Indian history, data principal versus data fiduciary, data processor, all definitions nicely covered, processing, personal data breach, child, notice and consent, duties of data principals. So yeah, on this, I hope to take your consent to share the presentation. Do share your presentation. There are a lot of people asking for your presentation. Very insightful. Yeah. And of course, thanks to all participants for being over here, in good numbers at this, Saturday evening. So thank you all participants for being with us, and just participate in the feedback poll, and then you can, thank you so much, everyone. Thank you, Narasimhan.
So much. Excellent session. Evening and rest of the evening, and have a great Sunday ahead. Thank you so much. Do not think too much about the DP. Probably you still have Monday to start off. Take a good Sunday break. Inhale and start looking at it from a Monday morning. Yeah. Thank you so much. Lovely meeting.
Thank you so much. Bye bye.
Thank you so much.
Thank you. Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Everyone just participate in the feedback poll. It's open. Those are yet to participate.
It's submitted, sir. How are you?
Good. Yes.
Yeah.
Yes. So
Yeah. Thanks.
Murtaza, I just want to make one announcement here.
Yes, please, Sanjeev.
Okay, so we are going to have our annual general meeting on 16th of September. So I request all of you to attend it in physical format. It is there in our office. Please attend it, because your participation in the working of ISACA Mumbai chapter is very important. And yes, as you participate in AGM and start volunteering for various ISACA activities, definitely you get a lot of opportunities to meet with the people and work for the community of information security professionals. So please join us that day.
Yeah, thanks, Sanjeev. Yeah.
Sure.
Thank you. Thank you, everyone. Bye.
Yeah, thank you all.
Thanks all the members. Thanks for joining. Bye.
Thank you, everyone. Thanks, Murtaza.
Thank you most for
Thank
joining
you.
us. Just few more seconds left for, in case anyone's yet to submit the feedback poll, just submit it, then we'll end the session. Yeah, thanks.
By the way, what is the timing to reach Mumbai ISACA chapter on 16th?
It's given in the notice, I believe. Yeah, around 5 p.m. Onwards, the activity start.
Okay, 5 p.m. is fine. Thank you.
Yeah, thank you. Yeah, feedback is open. So as a poll, you can see the feedback. So just do participate in the feedback as a poll, and yeah, WebEx poll is there. Yeah, thank you. Great. Fine. So thank you very much all. I'm ending the session. I believe everyone has submitted the poll. Yeah. Thanks all. Bye. Yogesh, you could see the poll, it's there. You may just keeping it on. Sir, poll nahi dikh raha. Right side pe, at the bottom right corner, you should be able to see a poll.
Okay. Even I am not able to see.
In WebEx, yeah. So poll was open, and it's
I am on the mobile.
Okay, so from mobile also you can participate. Yeah.
On the right side.
In fact, the pool has ended, so we are not able
ending the
to.
session. Yeah, ending the session, and we'll give the CPs based on the attendance here.
Okay.
So I believe some
Because we are not able to.
some
Pool
technical
has
problem.
ended actually.
Pardon?
Pool has ended, so we are not able to feel that. That means submit button is.
Yeah, it was open for 5 minutes.
Poll has ended. Even I could not submit it. Yeah.
Okay. Not a problem.
Okay, thanks.
Based on the time spent inside the session for this particular session, we'll allot the CPs.
Thank you.
So thank you very much, everyone. Have a wonderful Sunday.
Yeah, thank you, sir.
Thanks, guys.